Hello, my name is Max Davis. I'm a barrister at 30 Park Place in Cardiff, and I specialise in financial remedies. And I'm making this short video about private FDRs. There's been lots of support for private FDRs from the judiciary over the last few years. The president of the Family Division has spoken out in support of them. The previous president of the Family Division did so as well. And there's been guidance, obviously, from the lead judge of the Financial Remedies Court. I'm going to talk about how they fit in with the court process. And I'm guided by the Good Practice Protocol that was published in 2019. Here are some points. Firstly, at the first appointment, if the parties intend to engage in a private FDR, having discussed it, then that should be recorded in the preamble to the order. Ideally, the date for the private FDR, the identity of the tribunal, and even the location could also, if already resolved and determined, be recorded in the draft order. Importantly, the draft order will have to have a listing of a directions hearing to follow the private FDR, or any window that's been set for the private FDR to be conducted in. If successful, the private FDR can obviously result in a consent order, which can be filed with the court, no D81 required, because Forms E are on file. And if the order is approved, then that will bring an end to the case. Excellent news for the parties with their dispute having been resolved, and excellent news for the court with a lighter load going forward. If unsuccessful, then paragraph 10 of that Good Practice Protocol is of assistance. What's required is a full explanation given by the parties, a written explanation to the court, so that the next FRC judge that deals with it can be satisfied that a thorough FDR exercise has been taken place, and that the matter can therefore proceed and continue to final hearing. That explanation should not include any reference to without prejudice positions unless the judge particularly asks for them, because that would simply prejudice any judge reading them against hearing any future substantive hearings in the matter. And then the explanation should include details such as the date the private FDR was held, the tribunal that heard the FDR, the amount of time that the parties spent dealing with the process, and an assurance that offers were made on both sides and that an indication was given. That full explanation having been given to the court in writing, the court should not then require a further court-based FDR. And at that directions hearing that was listed in the first appointment order, the matter can be directed through to trial in the usual way. It's quite obvious that parties and the courts are going to have to identify which cases are appropriate for FDR at the moment at first appointment, whether they can be held by private FDR, and in most cases they can be. And then those cases can be moved forward, lightening the load on the courts suffering under the lack of resources that they are currently, and the difficulties that COVID-19 presents, and also clear some of the backlog that we all know is going to come when the restrictions are finally lifted and court can continue as normal. Thank you very much.